بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على خاتم الأنبياء والمرسلين سيدنا ونبينا وحبيبنا وقرة أعيننا محمد وعلى آله وصحبه وسلم. In our lessons on Mukhtasar al-Quduri, in the section on Muamalat, we have reached the chapter on preemptive rights, Shuf'a. Right? And Shuf'a, which basically entails that the general scenario is if somebody is selling a property, then the most proximate owner to that property has more rights to it than a third party. So that there are two aspects to it. One is there's a religious aspect that one morally should offer it to one's neighbor before selling it, unless sure that they wouldn't want it, right? When they can't, they can't afford it, whatever. Or at least to let it be known to them that you're selling. Right? Because if you make it known that you're selling and they don't offer, then that's up to them. There's a moral component to it. And then there's a legal component to it. The legal component being that in a Muslim society, legally, the person could demand that you sell it to them in court. And they would have more rights to it than a third party. And properly speaking, in a Muslim society, there should be a way of verifying. So, because one of the things that in societies, just like in the West, in order to avoid there being dispute over properties, there would be title deeds. A sales takes place when the transaction happens, but the title deed would be defined in order that there not be difference. Right? I sell you the property, you went in it, and I went and bought another property. Now, can I prove if there's no title deed? Can you prove that I sold it to you? I'm living there. That's an indicator. So it leads to dispute. So there'd be, so the practical moral thing, right, if we're living in a non-Muslim society, for example, is that if you're selling a property, that you should, depending on the situation, either offer it to your neighbor or let them be aware of it, right? So that they have sufficient opportunity. You don't have to go tell them, I'm selling it for 2.2 million or 1.2 million or 250,000, whatever the property may be, right? But you give them reasonable opportunity, right? Of course, people would try to avoid shuf'a in all kinds of ways. So we'll see what is the ruling of hilas in shuf'a. You don't like your neighbor, so you don't want to have them take it over. So they do all kinds of tricks. We'll see the tricks, right? Because you're selling your property, but you know that the person on your right doesn't want the person on your left to get the property. So there's ways you could sell the property without the person on the left being able to get it. And they do all kinds of tricks. So one way, you have a property, you sell it except for 2 meters along the wall. Right? That still belongs to you, so the guy has no preemptive rights, because the property is not adjacent to theirs. So there's all these kinds of tricks. And then it's kind of known that, well, technically it belongs to me, but khalas, that's sort of, it's yours. So these kinds of tricks. And normally, legal tricks are morally disliked or impermissible depending on what aims there are. If the intent is to deny a right, it would be particularly problematic. If the intent is to prevent the spreading of harm, then, it would be likewise. But let's see the shufa. Now, the shufa does not only occur with a neighbor, it can also happen with a partner. Right? Right? So, for example, if two people bought a home together, they own it 50-50. Now you want to sell off your home. Husband and wife are about to be divorced. They both own the property 50-50. Husband wants to sell off his property. And to spite his wife, he finds an Islamophobic, right-wing, neo-Nazi male with a criminal record to sell the house to, just to spite his wife. Okay? They co-shared the property. He has a moral duty to give her the opportunity to buy the property instead. Right? Right? People would want to be careful about who lives next to them. So this applies to the person who shares it. There's joint ownership of something. But then the neighbor, right? Because they used to say al-jar qabla ad-dar, the neighbor before the house. Right? Either for oneself, that you don't want a harmful neighbor, because properties, people will be very sensitive, because people, for example, like the way traditional Muslim homes used to be, that they'd be walled and the garden would be inside the house. And they say that's like the metaphor of the believer. The believer is relatively plain on the outside, and the garden is their heart. Right? The believer places emphasis on adorning their heart a lot more than they put emphasis on adorning their outward, while taking care of the outward, as the Sunnah teaches us. So, in all of these, there are considerations for this. Like, some people would, if they got established, they try to have family living next to family. Righteous people gathering together. Or people of similar backgrounds, if righteousness was not a concern. So that's the mahasin, that it fiha, and the ulama mentioned, and the Hanafis spoke a lot. It comes up in books of usul al-fiqh, and also they have individual works on mahasin al-sharia. And the Hanafis wrote a lot on that. Surprisingly limited amount of that is published. Amongst them, the work of Ad-Dabusi, for example, or Ad-Dabusi. Anyways, whose title I always forget, it's on my desk. So, from the mahasin of this is prevention of harm. So someone has a right not to have a partner come in that they wouldn't agree with, or a neighbor come in that they wouldn't be agreeable to. That's some of the benefits of shufa. Okay? So what is shufa, or this preemptive right? Right? In Arabic, shufa comes from shafa, which is one thing with another. Right? So the dual, you have a shafa wal watr. Something that's paired is the shafa, because it's 1 plus 1 with 1. That's shafa. And the watr, the singular. So shufa comes from the root meaning of is put one thing with another. So in the same root you have the notion of intercession. The notion of intercession. Shafa'a. Right? And shar'an, the commentator tells us, الشفعة تملك العقار جبرا على المشتري بما قام عليه. Right? Is to forcibly take property from the buyer with what بما قام عليه, with what the ultimate price was for them. بما قام عليه, because one of the ways, and we'll see why it's بما قام عليه. الشفعة واجبة للخليط في نفس المبيع ثم للخليط في حق المبيع كالشرب والطريق ثم للجار وليس للشريك في الطريق والشرب والجار، يعني شفعة مع الخليط. فإن سلم الخليط فالشفعة للشريك في الطريق فإن سلم أخذها الجار. Right? So shuf'a comes with degrees of association. With degrees of closeness. So he said, shuf'a is necessary, meaning is affirmed. Right? Wajiba ay thabita, is affirmed. Right? It's a right, it's a haqq. Firstly, for the khalid, there's the sharit al-mukhalid, for the partner who owns the property with the person, whether a majority partner or a minority partner, right? Firstly, the one who owns the property itself. Then it goes to lil khalid fi haqq al mabi', the one who shares in a right related to the property. The mabi' here is the property. How? Remember, our entrepreneur sister had that land. I have a building on the land. Right? So you want to sell the land, but I own a kashirb, which is the water access, or a pathway, a private pathway to get to my property. So let's say entrepreneur sister owns this land. I own a house on it. She wants to sell the land. I'm not a partner with her in the land. I'm technically a neighbor because my property was next to her property, but I'm closer than a neighbor. Why? Because I have a private road. Right, this is called haqq al-tariq. How does he translate it? So I have I have a right related to the property itself, which is like a path from my property to the main road, let's say, right? Then thumma lil jar, then to the neighbor, and this is al jar al mulasiq, the next door neighbor, and the neighbor that's considered mulasiq, the next door, because there's degrees of neighborness, right? There's the immediate neighbor, the mulasiq, and then there's the neighbor who's close, and then the one who's in your area. At one level, there's three types of neighbors, right? The immediate neighbor, whose property and your property is connected. Then there's the one who's near you, right? And the marja of that is the one who's considered close, within a few homes, either side and front and back. And then the third notion of the neighbor, the jar, broadly, which doesn't have to do with here, is one who's in your neighborhood. And some try to quantify it, 40 homes in each direction or more or less. And they said, what is customarily considered your neighborhood? But here, it refers to al-jar al-mulasiq, the next door neighbor, the neighbor whose property is connected to your property, even if you don't share, even if the door does not face the same way. وَلَوْ بَابُهُ, what's it say? وَلَوْ بَابُهُ فِي سِكَّةٍ أُخْرَى. Right? So their backyard and your backyard are touching. But they live on the other road. But the properties connect from the back. Right? So they have a preemptive right as well. Why? For obvious reasons, right? They're going to someone's going to buy the place, going to throw parties, whatever, and you want calm people, or you want loud people, whatever. You have your choices. Right? وليس للشريك في الطريق والشرب والجاري شفعة مع الخليط. Right? But the one who has ليس للشريك في الطريق والشرب, the one who has partnership with respect to the path or the water access, and the next door neighbor, they don't have a preemptive right with the presence of someone who co-shares the property itself. Right? Because the higher covers for the one less than that, right? So let's, and just one of the ways to understand this, even for oneself, is just make an example. Two people who co-share the property, husband and wife. Simplest example. They own the property together. Husband wants to sell the property off to his wife. Right? He's going to sell to a third party. Husband going to sell to the neo-Nazi. Okay? Wife says, I have a preemptive right. And they agreed. He's going to sell it for $2.5 million. She says, I'm an entrepreneur, I can buy it. And she got coaching from the entrepreneur sister, how to pay for it in installments. She helped finance it for her. So, what happens? She has a preemptive right. Morally, he should grant her that. If not, it can be demanded in court. But in the presence of the khaliyat, the next door neighbor, like they say in Arabic, ish dakhlu, what does the next door neighbor have to do with this? Right? When there's people own it together, right? Or, two partners in a company, they bought the building together. Now one partner is getting out of the business, but they're also part of that, they're going to sell off the co-owned property. Here, this person has more right to it than the one who had some access right, or some, which is the access right, which is for the shirb and the tariq, or the next door neighbor. فإن سلم الخليط فالشفعة للشريك في الطريق. And it follows this order, right? So if فإن سلم الخليط, if فلم يطالب بالشفعة, right? So if the one who has co-ownership of the property being sold, if they waive their right to shuf'ah, then it goes to the next person, which is then the right of preemption goes to a sharik fi haqq al-mabi', the one who has, who shares in rights related to the property, such as the passageway or water access, etc. Right? فإن سلم, and if they waive their preemptive right, أخذها الجار, أي حق له أخذها. Then the right of preemption goes to the neighbor, right? Right? And this applies to a private access right, such as we mentioned, someone, there's a property, like, the example we use. I own the house, I own a building on entrepreneur's plot of land. Am I expected to helicopter in? No. You would be morally bound to let me have a path, and that's a private path. So that private path, I own that path. Now, by owning this path, and of course, when you sold me the house, you got someone else to own the circle of land around my building, so that you're hoping I wouldn't get preemptive rights over your property, because you sold it to me, but you really don't like me and don't want me to own that part of land. Whatever reason, we're from different tribes, right? So then what happens? But you got your fiqh wrong, which is why you have to review your fiqh. Because by owning that private pathway, access pathway to my property, I have a right of intercession over that, unless someone co-owned the property with her. And there's some details in the commentary you can see, but this does not apply to a right to a public pathway, right? So she has multiple properties on the land, so it's a haqq am, and you can see that in the commentary. Okay. He says, وَالشُّفْعَةُ تَجِبْ بِعَقْدِ الْبَيْعِ وَتَسْتَقِرُّ بِالْإِشْهَادِ. Right? So the shuf'a, this preemptive right, tajib, it is affirmed with when the sale takes place. But it remains by having it witnessed. Right? So let's say I heard that she sold her property. Then immediately I have to exercise my preemptive right. I can't delay it. I can say, well, I'll decide 6 weeks from now. Why? Because the reason she's selling it, because she has some material interest in selling it. And the person buying it has a material interest in buying it. Now, if 6 weeks later I were to exercise my right, one or both of the other parties could be harmed. So the right has to be, my show of interest has to be immediate, but then I need to bear witness on it as soon as possible, as soon as reasonably possible, so that it sticks. Because if I just claim that, oh, I exercise my right, but she doesn't have any proof, then what happens? She would be harmed, right? 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 And if you don't immediately exercise your right to shuf'a, then the preemptive right goes. So the preemptive right is defined as a weak right, haqqun da'if. Right? يَبْطُلُ بِالْإِعْرَاض, as the commentator mentions. It's lifted by turning away from it, by not demanding it immediately. Some rights remain. لَخْيَارُ الْعِيبِ, right? Is a strong right. Right? Some rights, and that's something that as we go through the chapters of fiqh and as you study fiqh further, it's good to know what are the implications of this right. How long does it remain? What if you don't exercise it immediately, etc.? And if you review, we took many examples of different types of rights when it came to the options. The option of cancellation, the khiyarul aib, etc. But this is it's a quick right. Are you going to exercise the right of preemption or not? If you delay, but then after that, you could find out, but entrepreneur sister wanted to throw a curveball. So what does she do? She knows that, there's no one, I have really bad character, so nobody lives with me in the building. So she sends me a message at 3:45 a.m. So there's no one to witness it. Right? Wakes me up, says, Mr. Rabbani, I'm selling my house, the land for $2.5 million. So I need to get witnesses as soon as reasonably possible, right? Right? So that I'm not harmed. If she tries to curveball me, I have till morning time to get it, right? And also because, but then morally the person, if I show that I had that right, then the person should just out of court agree to sell it to me for the price it'd be sold to the other party. But if the person says no, then it goes up to the qadi. And the reason you need to witness the fact that you wanted to exercise your right of preemption, because judges don't deal with mere opinions. Judges deal with evidence. That's really important. In the Sharia, right, we have the notion that there are ultimately, the ahkamul hakimin is Allah subhanahu wa ta'ala, right? And the ultimate judgment is with Allah. In this world, complete justice is not possible. And trying to establish absolute justice would entail destroying everybody. So what is done is yuhkam bil-zahir. Husband goes to, husband goes to the judge and says, my wife is mean to me. The case won't be admitted. Said, Allah ya'inak, may Allah help you. Because that's something that cannot be dealt with in court. Intangibles can't be dealt with in court. Mere claims can't be dealt with in court unless accompanied by proof. Claims related to material rights and certain types of rights, there's a procedure for dealing with them, right? And then if the person remains wronged, then we know that there's a hereafter. And the power of belief in the hereafter is affirmed in a material thing by for example, I saw it, my landlord in Damascus was a drunkard. Poor guy. He was a good guy, was a drunkard. Had a very failing business. Even the building when Muhammad and I were renting, we had the ground floor apartment. Only the basement and the ground floor were built up. Even the first floor was al-adm, was just bare bones. It wasn't built up. So I asked him, I have a finance and economics background. I said, why don't you build it up, borrow some money, this, that. You're thinking corporate. And he was drunk while he's talking to me. He's like, yeah, Shaykh, already we're in a state of disobedience to Rabbil Alameen. And we fall short and this and that and khaifeen, but we fear Allah's punishment. What if we did something that now we're in a state of war with Allah subhanahu wa ta'ala? La naqdir. So we can't handle that. I'm already have so many shortcomings because I get drunk, and sometimes he'd walk in and say, well, yeah, Shaykh, id'i lana. Say, pray for us. Wallah. But he's still got the bottle in his hand, right? But this is the power of Iman, right? That people realize that there's a hereafter. Right? And that's a very powerful reality, right? So anyways. So this is a right. And then he says, وَتُمْلَكُ بِالْأَخْذِ إِذَا سَلَّمَهَا الْمُشْتَرِي أو حكم بها الحاكم. Right? When is the preemptive right owned? Meaning, when is the property to which you have the preemptive right owned? بالأخذ, when you take the property. Right? If the prospective buyer lets you take it. Right? By mutual agreement. أو حكم بها الحاكم, or أي القاضي. Now why are we talking about the buyer? Right? Wouldn't it be if the seller gives it? Because for me, the entrepreneur sold the property to Kilo Enterprises. Why do I care about Kilo Enterprise? I'm dealing with Entrepreneur Sisters Incorporated, right? She sold her property. I have preemptive rights over it. You would imagine that I would be exercising my preemptive rights with whom? With the seller. But the thing is, when the sale takes place, what happens? What is the hukum? The ruling of a sale is, when a sale happens, what? So, Entrepreneur Sisters sold to Kilo Enterprises. Ijab, Qabul. What happens when Ijab and Qabul happens? What? Transfer of ownership, right? Tamalluk wa tamlik. Transfer of ownership takes place at the point of contract. So now the property belongs to you. My preemptive right is, even though the property has moved to you, I have right to demand it from you. Now, so you could, now before that takes place, it should have been offered to me. in terms of akhlaq. In terms of akhlaq. If it wasn't offered to me, then I can go to you. Now, if you're tayyib, you should recognize that I have a shar'i right of shuf'a, I have to preemption, so you should make tanazul. You're morally bound to step down. Either if you believe me, and even more so if I have witnesses. Right? Of course, this gets really messy, which is why there has to be legal systems in place for this. And people dealing in real estate should deal with it. There's many reasons why real estate agents and agents in general are considered of the worst people in society, historically. Amongst them, because they don't want all of this. Right? Because does a real estate agent really want neighbors to be selling to each other? No, because then what will the real estate agent do? Right? Because the real estate agent goes and says, Mr. Rabbani, entrepreneur sister wants to sell. No, entrepreneur sister would just offer it straight to me. Right? Why would we enter a third party between neighbors? Anyways, so agents are complicated. That's why lawyers also, it's a strange profession Islamically. Right? A lawyer, all they are is a type of wakil. They're acting on behalf of one party. Right? That's why the term for it is wakil in classical Arabic. Right? Anyways. So, وإذا علم الشفيع بالبيع أشهد في مجلس ذلك في مجلس العلم, right? على المطالبة. As soon as the shafi', أي من له حق الشفعة, right? As soon as the one who has the right of preemption, من له حق الشفعة, finds out about the sale of the property, right, when the news reaches them reliably, then they must bear witness in that gathering that they are demanding it. Or, right, it's called talabul muwathaba, right? Now the ishhad is a condition for you being able to make your case, because ultimately between you and Allah, you said, I want to exercise the right of preemption, but there's nobody there, but then how can you establish that right? That you have Yawm al-Qiyamah for that, right? So, and there's some details you can see. ثم ينهض منه فيشهد على البائع إن كان المبيع في يده. Then one rushes from that to bear witness before the buyer, if the buyer already has the property in their hand. أو على المبتاع, or the بائع, they go to the بائع, which is the seller. You go to the seller. As soon as you find out the sale, if the property is still in the hands of the seller, you say, look, I found you sold it to Kilo Enterprises, but you know, the ownership hasn't, you haven't transferred the qabd, possession to the buyer, then I've exercised my preemptive right. You would be bound to give it to me, right? But I should bear witness to that, so that if it needs to go to court, I can establish proof that I exercised my right of preemption, and also that I took it to the seller, that I exercised my right of preemption. I bear witness to that, and you'd be morally bound to just give it to me. Of course, I'd have to be able to prove that I can pay for it, right? For obvious reasons, right? There's assumed details. But if the qabd had happened, so the buyer Kilo Enterprises had taken possession of the property, then I would go to you and say, look, I exercise my preemptive right. Here are the upright witnesses. You know. Of course, he'll say, prove that you can pay it. If we can agree, then we don't need to go to court. That's better. But if he refuses, and no, you know, goes into this whole emotional why he really needs the property, right? Emotion does not counter legal rights. But then we say, okay, let's go to court, and it would be my right. But what if I can't access A or B? How? She owns the property, but she lives in Singapore, and Kilo Enterprises has moved to Istanbul. Do I have to fly to Singapore or Istanbul? No. I bear witness at the property that I'm exercising the right to this, of preemption to this property. أو في العقار, right? Because the right is related to it, and there's scenarios where I may not be able to access the seller or the buyer. They're overseas, for example, right? Although, of course, you could also, correspondence is also valid, right? فَإِذَا فَعَلَ ذَلِكَ, if the one who has the right of preemption does this, استقرت شفعته, then their right of preemption becomes established. And after doing this, وَلَمْ تَسْقُطْ بِالتَّأْخِيرِ عِنْدَ أَبِي حَنِيفَةَ. After doing this, the right is not lifted, according to Abu Hanifa, after this. So then they just delayed in processing it, in coming to an agreement, whatever. Right? And this is the fatwa position. Oh, this is at least Zahir al-Madhab, right? And then Al-Lubab mentioned something interesting, right? قال في العزمية فتاوى العزمية وقد رأيت فتوى المولى أبي السعود, and this is Abu Saud Shaykh al-Islam Abu Saud al-Imadi. The author of the great tafsir. He was the Shaykh al-Islam of the Ottoman Empire, the most brilliant jurist of the Ottoman era. There are days where he gave more than 1,000 fatwas in a day. It's amazing, because he had a whole team of muftis around him. They would prepare the questions. They would handle the simple questions. But the really delicate questions, they used to prepare the questions in a way that was, they just got to the key issue, like what needed the mind of the mufti, Shaykh al-Islam Abu Saud. Precise question, precise answer. And he churned through them. It was brilliant. Of course, took many stances that others disagreed with. Who was his contemporary? Omar? Imam Birgivi. And he gave some Abu Saud, but Abu Saud was in a position of where he was giving fatwa at the level of the Khilafah, of the Ottoman Caliphate. He was the Shaykh al-Islam of it. Imam Birgivi firmly disagreed with him with a whole bunch of things. And he firmly disagreed with Imam al-Birgivi on a bunch of things. It's very interesting. They had the back and forth. Anyways, so here it's referring to Abu Saud. Abu Saud did not write a book of fatwa though. And he was asked, why didn't he compile a book of fatwa? It says, يكفينا تكفينا البزازية أو كما قال. The fatwa al-Bazzaziyya are sufficient. وقال محمد إن تركها شهرا بعد الإشهاد بطلت شفعته. Abu Saud said that after making the two witnesses, the witness that he's claiming it, and the witness with either the seller or the buyer or at the property, after there's the two witnessings. After that, if he delays it unnecessarily to actually go forth and then make the payment, etc., it's lifted. The fatwa would be, what's the adopted opinion would depend on the land, right? And many you can see many said the fatwas in the opinion of Imam Muhammad, not because of strength of evidence, but because of, that a lot of people exercise the right of intercession. I just don't like Kilo Enterprises. So I say, I want to take intercession. But then I don't do anything about it. So he's stuck, he can't move into the property, etc. But at the same time, I'm not doing anything about the right. How? By making the payment. You already made the payment. So you're in limbo. Right? So the Imam Muhammad said you have 1 month. Because 1 month is enough to gather your resources, etc. to be able to make the payment. Okay. We'll take 2 issues and then we'll pause for Maghrib. He says, وَالشُّفْعَةُ وَاجِبَةٌ فِي الْعَقَارِ. The preemptive right is wajib. It's thabit fil aqar, in properties. Right? Whether entire properties, land or building, or in parts of a building. Right? Like the top floor, like a floor. If you're selling the top floor, the person below you has a preemptive right, for example. Right? وَإِنْ كَانَ مِمَّا لَا يُقْسَمْ. Even if it's something that's not divisive. وَلَا شُفْعَةَ فِي الْعُرُوضِ وَالسُّفُنِ. There's no right of preemption when it comes to al-urud is transferable items. Your car is parked next to mine. So you sell your car, I have a right of preemption. Or the 2 cars are from the same set of limited edition vehicles. No. Why? Because the right is affirmed by transmission from the Prophet ﷺ with whom? With respect to property. And number 2, because the harm, because transferable items, the harm of adjacency is not established. Wasufun, or ships, that these ships are in the same harbor. If I buy ship 7 and ship 6 and 8 don't like me, then do something about it, right? وَالْمُسْلِمُ وَالذِّمِّي فِي الشُّفْعَةِ سَوَاء. And a Muslim and a non-Muslim with respect to the right of shuf'ah are the same. Because they share in the cause, the sabab, which is, the adjacency, and the wisdom, prevention of harm, attaining of benefit. So they have the same rights in this. Right? So we're going to pause here for Maghrib and then continue by looking at the derivative rulings of shuf'ah. Bi-idhnillahi ta'ala. And we're avoiding too many details on it because it's not a right practically we're able to exercise legally. But there's a moral dimension, don't forget about that. Okay? And if you're a real estate agent, just fear Allah subhanahu wa ta'ala. But try to avoid being a real estate agent. Also the aspect of you're facilitating people to get into riba and for you to go and, anyways, I won't say anything about that. Bismillah. Okay, so وإذا بسم الله الرحمن الرحيم وإذا ملك العقار بعوض وهو مال وجبت فيه الشفعة. Right? If a person owns a property in exchange for something that is of material value, that is what's due in the shuf'a, right? ولا شفعة في الدار التي يتزوج الرجل عليها. Right? There's no preemptive right for the property that you give as mahar. Right? أي جعل مهرا أو يخالع المرأة بها. So it's given in exchange for khula. And of course, here, if you're not sure of the rulings of khula, you should be reviewing khula. Because when is it permitted to accept money, to demand or accept money for khula?
There's no fault on the man.
If the fault is from if the cause of the breakup of the marriage, meaning the taqsir, who was not fulfilling their rights, if it's the woman. But she says, no, I can't fulfill it, I want out, then she can do so by paying. I have a friend, the wife decided, you know what, I don't want to stay resident, I want to travel the world. Like I'm getting to 30, I want to travel the world. And that a little kid, he says, this is not reasonable. He said, then divorce me. He said, I don't want to divorce you, because I love you. So he says, then I want khula. So here, she's chosen not to fulfill the rights and responsibility of marriage, then he can demand khula, like a payment for the khula. But if the husband who's abusive or not fulfilling their rights, and the wife wants out because the shortcoming is from him, it is sinful for him to demand payment for the khula, and it's sinful for him to accept it. That's mal khabith. And morally, he should return it back. Allah. But if it's given as a badal al-khula, أو يستأجر بها دارا, right? أو يصالح بها عن دم عمد أو يعتق عليها عبدا, right? Or if the payment, like someone bought a small house, someone sold a small house, what is the payment? So they had a small property out of town, they made the payment of it, 10 years of renting an apartment in downtown Toronto. How can you? So that could not, because, right? These are not considered mal, right? Because the right of renting a property, right, is a manfa'a, is a benefit. It's not itself mal, right? Or the settlement for a deliberate killing, or if the slave had a property and say, okay, I'll make you free if you give me that house that the slave has owned, then like you can't quantify that payment. أو يصالح عليها بإنكار أو سكوت, or a settlement made in a state of denial or silence. Right? And we look at settlements when they come, because the sulh, right, a settlement, the obvious case where you'd settle if someone makes a claim, you admit to owing something. You say, let's settle on this, right? So let's say you borrowed $5,000 from me. Then we forgot. Then I say, by the way, you owe me $5,000. I can't pay $5,000. So okay, let's settle on $3,000. That's sulh when there is agreement. But let's say you owe me $500,000 and now you become MP for Mississauga West. So I make a claim, you owe me $500,000. Now you're a prominent personality and you know it's going to make you look bad that you owe me money. So you're denying. Right? One case is you can deny a right, but we can settle. Say, look, I'll give you 100,000. I don't accept this, but I don't want to take it to court. And that's valid in the Hanafi sulh. It's called a sulh ala inkar. The Shafi'is did not like this because they considered munkar. And you can ask Shaykh Badi about the hows and whys. The Hanafis took the principle that Allah subhanahu wa ta'ala says, وَالصُّلْحُ خَيْرٌ, that all settlement is good. Because it avoids dispute. At least if a false claim is being made against me, I'm rewarded for settling, even if I believe it wasn't owed. I don't have to settle. It's no moral duty. I have a right to seek my right. But if I chose to step down from my right and avoid dispute, I'd be rewarded for it. Or sukut. I don't want to say whether I'm owed the right or not. I just want to pay up and I'm going to shut up and I want the other person to shut up. So I pay. Because again, أو يصالح, and it should be عنها, as the commentator mentions, and others as well. So فإن صالح عنها بإنكار أو سكوت, right? So don't correct the commentary. You should put a note, right? If one settles the property, because a settlement is not actually a sale, right? So we disputed who owns that land. So we settled that, okay, it's yours, but you pay me this much. That's not really a sale, right? فإن صالح عنها بإقرار وجبت فيها الشفعة. But if the settlement was made due to admission, إقرار, right? Then that's like a sale, right? So then the right of intercession is admitted. So the ideal case is they would settle it between seller, the one claiming the preemptive right, and the buyer. Right? Within that triangle, they managed to deal with the preemptive right. But they didn't, now it goes to court. So what happens in court? Let's see. وَإِذَا تَقَدَّمَ الشَّفِيعُ إِلَى الْقَاضِي. Right? If the person who has the right of preemption, الشفيع يعني من له حق الشفعة, goes to the judge. فادعى الشراء, and claimed that a sale has taken place. وطلب الشفعة, and they seek their preemptive right. سأل القاضي المدعى عليه. Right? The judge asks the one the claim is being made against. Right? Do they own the property, etc.? They inquire. فإن اعترف بملكه الذي يشفع به وإلا كلفه إقامة البينة على ملكه. Right? So if he admits to owning the property that the intercession is being made regarding, right? So entrepreneur sister sold to Kilo Enterprises. So who owns the property now that I'm seeking the preemptive right? It was sold to Kilo Enterprise. So Qadi asks the buyer, do you own this? He says, yes, I do. Right? Then he admits, then khalas. and if the right of preemption that needs to be established, and that's it. وَإِلَّا, but you don't want to admit to it, because you're like, if you admit to it, you're going to lose it. So you're like, I exercise my right to silence. Okay? وَإِلَّا كَلَّفَهُ إِقَامَةَ الْبَيِّنَةِ عَلَى مِلْكِهِ. Right? Then they will be forced to establish that you own it. Because if it's in your hands, like it was her property, why is it in your hands now? So I'm not, you don't want to admit that you own it. If you admit you own it, it's mine. Then you would have to be, the Qadi would want to determine that you own it. And this is why they established the system historically of property registers. Yeah. Sijil al-Milkiyya. Right? فإن عجز عن البينة, but if he doesn't have proof that I own it, so he would not admit it, he doesn't have proof that he owns it, استحلف المشتري بالله ما تعلم أنه مالك للذي ذكره مما يشفع به. Then they would be forced to do what? To swear by Allah that they don't know that they own what they are being where the right of preemption is being exercised. Right? Because a claim is being made against you. If you admit to it, then you lose your property. Right? So you're effectively denying. Because you did not admit to it, you didn't give proof that you own it. Then you have to swear an oath that you don't own it. That it's just in my hands. I just borrowed it. You have to swear by Allah so that you're not making a false claim. Right? فَإِن نَكَلَ أَوْ قَامَتْ لِلشَّفِيعِ بَيِّنَةً. Now if you refuse to swear an oath, right? So you did not admit, you did not bring proof of ownership, and you refuse to swear by Allah. Then, أَوْ قَامَتْ لِلشَّفِيعِ بَيِّنَةً. Or the one who has the preemptive right has proof that you bought it. Then, I can prove that you own it, then, and my exercising of my preemptive right was sound, then the Qadi would make a ruling that it belongs to the one who has the preemptive right. You have to hand over. سأله القاضي هل ابتاع أم لا? Right? Right? Then the Qadi would ask you directly, did you buy the house or not? Right? فإن أنكر الابتياع قيل للشفيع أقم البينة. Right? If you refuse to admit that you bought it, right? Why would you refuse to admit it? Because you know that the one exercising the preemptive right, if you admit you bought it, and I witnessed the claim of preemptive right, right? طلب الشفعة, I made ishhad of the طلب الشفعة, and also when I went and bore witness of it, then khalas, you'd lose your property. So the Qadi would ask very specific questions. Did you buy it or not? If you deny that, then the shafi'a, the one exercising the preemptive right, would be told, أقم البينة, establish the proof that you purchased it. Why? Because unless I can prove that you bought it, if you're denying that you bought it, and I can't prove that you bought it, then on what basis am I claiming the right of the preemptive right, حق الشفعة? فإن عجز عنها. So I can't prove, I'm incapable of proving that you bought the house. استحلف المشتري. Then you're made to swear. بالله ما ابتاع. Like, by Allah, I didn't buy the house. أو بالله ما يستحق علي في هذه الدار شفعة من الوجه الذي ذكره. Or, by Allah, this house, this property there is no preemptive right on it in the manner that is mentioned. And that has to do with if they try to do some tricky business. House A, property B, next to each other. The property B says, property A was sold, I'm the neighbor. But there's the strip of land case. I say, well, I sold 99% of the property, not the 1% that's adjacent to the wall. That still belongs to the original neighbor. So he's not denying that the sale took place. He's saying, I deny that no right of intercession is due in the manner mentioned. That's sort of legal language, right? For many different possibilities, some of which are mentioned in the commentary. Now, there's a problem in the claim of preemption. What's the problem? Someone could make the claim, but they don't have the money, right? But imagine, there's a danger. Who would take $1 million to court? Right? Because there's danger. So وَتَجُوزُ الْمُنَازَعَ فِي الشُّفْعَةِ, the dispute regarding intercession, i.e. raising the issue to the judge, is permitted. وَإِن لَمْ يُحْضِرْ الشَّفِيعُ الثَّمَنِ, even if the one demanding the right of preemption does not bring the sale price to the court. The qadi would accept hearing the case in dispute without the payment being present. إلى مجلس القاضي, without the price going to the majlis of the qadi. وإذا قضى القاضي بالشفعة لزمه إحضار الثمن. However, the qadi says that yes, you can exercise your right of preemption, then they're forced to bring the price, right? And this is the position of Imam Abu Hanifa, because the al-ghalib in the early generations was amana of people. People were trustworthy. They would make a claim unless they could fulfill it. But وعن Muhammad, in the position it's related from Muhammad, لا يقضي حتى يحضر الشفيع الثمن, that the qadi would not make the judgment. The qadi would be ready to make the judgment. So okay, I'm willing to make the judgment, but demonstrate your ability to pay. If he demonstrates his ability to pay, okay, make the payment, bring the payment, then I'll make the judgment, right? And this is one narration from Abu Hanifa. But in terms of strength of evidence, they stuck with the position of Abu Hanifa in this. But in terms of fatwa, right, this is the kind of issue where it returns to what the qudat, the judges deem to be the law of the land, right? Because there's a clear interest of avoiding establishing a claim and then not exercising and not paying, because it يبطل حقوق الناس. Okay. وللشفيع. Now, what if someone exercises the right of shuf'ah? Right? Because just imagine, party A sells, so enterprising sister sells 2 kilo properties. I find out that the property next to mine is being sold to a third party. So I exercise the right of shuf'ah. But then, was I trying to buy the property to begin with? No. When I discover, then I exercise my right, then I discover what? There's a aib in it. There's a defect in the property. Right? Or I exercise the right, then I see the property and it's awful. Right? Because I want to exercise the preemptive right, but then I discover that it has defects or it's not pleasing to me. Must be a case of much ado about nothing then. So he tells us, وَلِلشَّفِيعِ أَنْ يَرُدَّ الدَّارِ بِخِيَارِ الْعَيْبِ وَالرُّؤْيَةِ. The one who has the preemptive right has the right of returning it with the option of cancellation due to defect, خِيَار الْعَيْب, and or خِيَار الرُّؤْيَة, the option of inspection. That upon seeing the product, say, I don't like it. Why? Because I don't. Right? And the reasoning being, لأن الأخذ بالشفعة بمنزلة الشراء. Because when you take something through preemptive right, it's like a sale between the one who exercised the preemptive right and the original owner. So the options that arise in a sale arise for the shafi'a, the one who exercises the haqq al-shufa. Okay. وإن أحضر الشفيع البائع والمبيع في يده فله أن يخاصمه في الشفعة. If the person who has the right of, who has a preemptive right, who has haqq al-shufa, brings the seller to the qadi. It doesn't mean drags him, like he says you have to come to the qadi. And the item, the property that was sold is still in there, fi yadihi. Of course, how can you have the property in their hand? Meaning, it's still in their qabd. They still have, the hand over it, as we would say, they have possession of it. Then, because he's still not given, transferred the possession of it, so it belongs to Kilo Enterprises, but the qabd hasn't taken place, the possession hasn't taken place, then I don't have to argue with you, I can just take you to court, give it to me, right? Right? So in this case, I can initiate proceedings, right? فَلَهُ, so the shafi'a, the one exercising preemptive rights, has the right to raise the issue with regarding the intercession. However, لا يسمع القاضي البينة حتى يحضر المشتري. Right? But the qadi will not listen to the evidence being presented until the buyer comes, because he's an interested party, because legally he owns the property even before the qabd. Right? And you need to review what is the ruling of qabd with respect to aqar that came earlier in sale. So once the buyer of the property comes, فَيَفْسَخُ الْبَيْعَ, then the qadi can cancel the contract بِمَشْهَدٍ مِنْهُ, in the presence of the buyer or their representative or their lawyer, their agent. وَيَقْضِي بِالشُّفْعَةِ عَلَى الْبَائِعِ, and the judgment of that the preemptive right had been exercised would be then made against the بائع. وَيُجْعَلُ الْعُهْدَ عَلَيْهِ, but in this case where we brought the seller, the judgment would be made against the seller, and the duties of the rights arising from this exercise of the preemptive right would be upon the bai'ah, on the seller, because it was still in their hand. Now, what if the right of shufa was not immediately exercised? He tells us, وَإِذَا تَرَكَ الشَّفِيعُ الْإِشْهَادَ حَتَّى عَلِمَ وَهُوَ يَقْدِرُ عَلَى ذَلِكَ بَطَلَتْ شُفْعَتُهُ. If the one who has a preemptive right left bearing witness to their exercising of the right, and when they knew about it, when they knew about the sale taking place, for which they would have a preemptive right, and they were able to have it witnessed. So it's the 2:45 a.m. case, right? That reasonable that first thing in the morning you'd gather the witnesses. Then the preemptive right is cancelled because it's a weak right. وَكَذَلِكَ إِنْ أَشْهَدَ فِي الْمَجْلِسِ. And the same thing, the right ends if you bore witness in the gathering. You heard reliably that the property was sold, so you bore witness. وَلَمْ يُشْهِدْ عَلَى أَحَدِ الْمُتَبَايِعِينَ. But then you didn't go and claim your preemptive right, either from the seller or from the buyer, nor at the property. The Singapore, Istanbul case, right, where the buyer and seller are away, then you didn't go to the property and publicly bear witness that I'm exercising the preemptive right to the sale that I'm aware has taken place. Now, what if I have the preemptive right to that property, but they really want the transaction to take place? Why? The buyer really wants that particular property, and the seller really wants me out. They can't stand me doing classes there. It's too noisy and it wakes up the ducks or whatever, right? So they want me out, right? So what happens? I claim preemptive right there. Oh no. So what happens? They say, look, let's both pay him $50,000 for him to drop his preemptive right. So that's the next case. وَإِنْ صَالَحَ مِنْ شُفْعَتِهِ. If I made a settlement, sulh, from my preemptive right, in exchange for some material consideration, عِوَض, that I took possession of, then my preemptive right, بطلت الشفعة, then my preemptive right is ended. But وَيَرُدُّ الْعِوَض, but this settlement payment is not rightfully due. Because in the Sharia, what am I settling for? There's nothing of material value that I'm settling for. So this is considered like rashwa. It's considered like bribing me. And there's many kinds of payments and so on that are not due. Someone was explaining how in their company, they want to hire people to do advertising for them on a performance basis. If you get the results, you get payment. If you don't, you don't. Shar'an completely haram. Right? Because it does not fit. It's not a sale, it's a service. They provide you a tangible, a definable service. You make a payment. The result is not a service. Right? The result is not a service. So similarly here, right? If you make this settlement, there's two steps. If you make a settlement like this, step one is, I lose my preemptive right because I dropped my right. But we would all the parties to that settlement would be sinful. And the one who bears witness to a right that is not due, they would also be sinful. Why? Because it's shahada al-batil. Right? And a rashwa, a bribe, the definition of rashwa is ما يؤخذ لإبطال حق أو لإحقاق باطل. This one definition of rashwa. A bribe is that which is taken to negate a right or to affirm that which is not due. This is from Dustur al-Ulama. It's a very good book. Now, what if I'll do a replacement? It's Zubair who has the right of preemption. Entrepreneur, Incorporated sells to Kilo Enterprises. Zubayr really wanted that property because Zubaydah loves that property. As soon as he heard that you sold the property, Zubayr has a heart attack, he dies. Does Zubaydah inherit the right of preemption? That's the next case. وَإِذَا مَاتَ الشَّفِيعُ بَطَلَتْ شُفْعَتُهُ. If the one who has the right of preemption, Zubayr, dies, rahmatullahi alayhi, his right of preemption is annulled. Of course, it's not that he could exercise it after death, i.e. لَا يَنْتَقِلْ إِلَى وَرَثَتِهِ. It does not transfer to their inheritors. So keep his heart beating. Right? Like put him on life support or whatever. وَإِذَا مَاتَ الْمُشْتَرِي. But let's say Kilo Enterprises backed out of the sale. Right? So we had someone else. Right? If the buyer dies, لم تسقط. The right of preemption is not lifted. Because the property gets inherited by whomever, that does not lift the one with the preemptive right, their right. The fact that they died doesn't affect me. Right? وَإِنْ بَاعَ الشَّفِيعُ مَا يَشْفَعُ بِهِ قَبْلَ أَنْ يَقْضِيَ لَهُ بِالشُّفْعَةِ بَطَلَتْ شُفْعَتُهُ. Let's say if the one who has the right of preemption sells the property that gave them the preemptive right, or sold that which gave them the preemptive right, which is either the property or the tariq or the haqq al-murur, etc. Then, before the qadi judged that their preemptive claim was valid, then the right of preemption is lifted. Because what's the scenario? Zubayr has a preemptive, so there's property A belonging to entrepreneur sister. Property B belongs to entrepreneur sister. Property C belongs to Zubayr. Zubayr doesn't like property C. He wanted property B. So when entrepreneur sister sells property B, Zubayr says, great, I'll claim property B. How will he finance it? By selling property C. If he was smart, he'd have to wait till the judgment happens. Right? So what he does, he claims property B, and while it's still in process, he sells off property C. What happens? By selling it off, on what basis are you now taking to court that you're demanding property B? Because the ownership does not transfer until the judgment is made or it's handed over. And this also relates to the principle, and it's a principle of not being hasty. That من استعجل الشيء قبل أوانه عوقب بحرمانه. That whoever hastens a matter before its time is punished by losing out on it. And this is one of the examples of that. Now, what about conflict of interest? Conflict of interest. وَوَكِيلُ الْبَائِعِ. The agent for the seller, if they sell on behalf of the owner, إِذَا بَاعَ وَكَانَ هُوَ الشَّفِيعُ, and they're the one who would have the preemptive right, فَلَا شُفْعَةَ لَهُ, because لأنه متهم, they have no preemptive right. وكذلك إن ضمن الدرك عن البائع الشفيع. Right? So the first case, entrepreneur sister has property A. She's selling property B, but she's too busy to sell that. Property not big enough, right? It's like one of the big problems that the big tech companies are having, that we have now $4 trillion tech companies. Some of the problems is even big projects don't make sense for them. Like a $1 billion project does not make sense for Google. Why? Because it doesn't even represent 0.1% of their revenues, of their worth as a company. $1 billion project is not that small. But for them, nothing. It's not even like a fly on their shoulders. That's one of the, so it's a David versus Goliath scenario. We just ask that the Davids be righteous. Anyways. So, entrepreneur sister, who's a righteous Google, gets Zubair, owner of property number C, to be the agent to sell property B. And Zubair agrees. Right? So Zubair goes and sells property B to Ahmed Kilo. And then he comes and I made the sale for, now I want the preemptive right. It's not accepted. Because there's a conflict of interest, and the presumption would be that even though entrusted to sell it, how much would he have sold it for? For a low price. Why? Because he wants to exercise the preemptive right. It's not acceptable. And likewise, كذلك إن ضمن الدرك. If he serves as a guarantor, that anything that arises in this transaction, I am your guarantor. Right? That's ضمان الدرك. That yes, because entrepreneur sister is not sure about selling to Ahmed Kilo. Who is this guy? Right? Because he's going to pay in installments. They say, I'll be the guarantor. If anything happens, you can demand payment from me. So she sells for a lower price than she would sell to a stranger. And then I come, I am the Shafi'ah. I have preemptive rights. But because she only made the sale because I stepped in and there's a conflict of interest. Right? And that goes back to the قاعدة لأنه سعى في نقض ما تم من جهته. Because the transaction will only complete through me, so I can't be the party who annuls the transaction. وَوِكِيلُ الْمُشْتَرِي إِذَا ابْتَاعَ فَلَهُ الشُّفْعَةُ. But the agent of the buyer, if they're the one who made the sale, who made the purchase on behalf of the interceding party, they do have the preemptive right. I mean, it's not exactly the nicest thing to do, because it's also the principle of let the buyer beware. You're buying the property next to my property. I'm the agent on your behalf. The onus is on you then. Don't make me the agent for that. Of course, akhlaqiyan, it's not the nicest thing to do, right? Now, what if the sale of the property has an option of cancellation related to it, right? And this goes back to something that you should be very familiar with, that what is the consequence of the option of cancellation? So, since I'm no longer an optimist, we're going to pause here and you can review. That when there's a khiyar, let's say simple khiyar al-shart, that A sells to B with the option of cancellation. Zubair and Zubair are divorced. Sad, but life happens. So Zubair sells his plot of land to Zubaydah. But Zubair got married to someone else. Zubair got married to Salma. Right? But he doesn't know her that well. He doesn't know if Salma would want to live next to Zubaydah. Because we could tell Zubair in advance, she won't. Right? because she'll be jealous. She's heard all the Zubaydah stories. So what happens? Zubair and Zubaydah own property next to each other upon divorce. Zubair, so what happens? Zubair buys a property from Zubaydah with khiyar al-shart, with the option of cancellation for 3 days, maximum according to Abu Hanifa, or with a khiyar al-shart of 15 days, according to the call of the Sahibain, which is the fatwa position according to the Majalla. I think it's item 300. We went through that. So what happens and why? Right? So we'll continue from there and look at the other rulings related to the Shufa. Shufa is a long chapter because there's many moving parts to it. So we'll finish it off. The practical application is one sees a broader value in our deen, which is that neighbors have rights. Also, we saw a subtle point that not every kind of settlement is permitted in the Sharia. The Sharia is actually pretty strict on settlements. The settlement needs to be to something that has recognized material value. Right? Also tells you that something seems reasonable. I'm dropping my right to make a claim of preemption. Pay me. Not everything is allowed. Right? And there's a lot of things like that. Let's say Zubair's best friend is a medical doctor. Zubair's an artist. He would describe himself artist and lover. That's his business card. His friend is neither an artist nor a lover, but he's a successful doctor. Boring. He's a BOD. Boring old doctor. When I decided to marry Umar, this one guy came to propose. He came down from Ottawa. He's a medical doctor. I had like zero career, no career plans. I knew that he was going to propose to Umar, but I couldn't make it public yet. So she didn't know that he was going to propose to her, but he'd confided in me. I couldn't tell him anything because it wasn't public yet. And it was very funny because all meeting I was just making dua that, okay, I hope, right, this doesn't affect everything. Because at least if the parents found out, I had no case. But alhamdulillah, it's good to marry people who have strength of resolve, because alhamdulillah. Anyways, so in this kind of situation, what if I told the doctor guy that, look, if you drop your proposal, I will pay you $500. I can't do that. That's just a bribe. Not every settlement is allowed. Right? And that's why a number of ulama wrote on the ahkam of rashwa. Because a bribe in the Sharia, amongst them is Sidi Abdul Ghani Nabulsi has a very good risala. I stumbled upon it recently. Right? Many kinds of settlements are, because there's no material right. Like, what is the material right of a proposal? Right? So you can't. Right? So we'll look at that. Just review the issue of the khiyar. We will stop there. Wa sallallahu ala Sayyidina Muhammad wa ala alihi wa sahbihi wa sallam. Walhamdulillahi Rabbil Alameen. Yes? Sorry?
Does this apply also to co-sharers?
What do you mean co-sharers?
Like if two people own 50% of, say, a car.
Yeah, no. Shufa is in property. Simple. Now there's an akhlaqi element that you're selling the car. Let the person who owns it with you have rights over it. Because they agreed to buy it together with you, but you sell it to the neo-Nazi. They probably would want to share a car with a neo-Nazi. Now there's fiqh on what happens if things like that happen, but it's not binding. Virtue is not binding. Like, what can you say? He's not being nice to me. Right? That's not enforceable.
What if instead of settlement, right, of preemption, and then they sell it to the original buyer for like 50,000 more.
That's something completely different. Yeah, that's good. That's a possible way of doing it. Yeah, you exercise your right to preemption and say, look, you really want it? I'll sell it to you for 3 million, not 2. The owner can sell what they want for whatever price they want, as long as there's no taghreer, there's no gharar, no deception, and no deception and no cheating, no khiyana. Nusх is recommended. I shouldn't sell it to you excessively, but without cheating. Let's say this is the worst edition of the Lubab. It's not the worst, but it's pretty high up there. And I personally don't like the book because I actually studied a few durus with the editor, and I walked out on the dars because he was speaking ill, one of the great imams of this deen. He started coughing and walked out, never to see him again. I'm not particularly happy with having this edition, but I'd worked hard on this edition before. I don't know how it's connected with the dars, but I've worked hard on the edition. I have all kinds of footnotes in it. One day I'll get them out of it. So I don't like this edition. I want to get rid of it. Let's say the book, a new copy of the book sells for $20. Let's say. How much did you pay for it? Yeah, about $20, right? Let's say you consider my footnotes to be, although they're actually very valuable, to be a total disaster. So actually reduce the value of the book. Let's just say. It's got my stamp on it, which I've lost now. There are all kinds of different things. So, you ask me, I'd like a copy of the Lubab. I say, okay, it's $200. You pay for it. There's a principle. Let the buyer beware. If I tell you that's a good price, I've committed sin. Because that's taghreer. You could take me to court for that. Because there's two things. That's ghabn fahish, that's selling it for excessively above the market price. وَهُوَ مَا لَا يُتَغَابَنُ بِمِثْلِهِ عَادَةً, is that which does not enter within the normal market price variance. Some places you get it for 20, other places you get it for 25, maybe 30, like whatever, depending on the item of sale. So this does not, مَا لَا يَدْخُلْ تَحْتَ التَّقْوِيمِ الْمُتَقَوِّمِ. No one would value it in that range in the marketplace. So for a sale to be considered a cancelable deception and also morally sinful, there's two things, which would be الغبن الفاحش مع التغرير أو الخيانة, like where I deceived you. And deception, it's enough to say it's a good price. Now what's enforceable in court gets a little tricky. Now deception is sinful even if it's not بغبن فاحش. But can that be cancelled in court? That's a separate matter. Right? And of course, sellers sin in that all the time. Say, this is the best price you'll get for the book. If it's not, it was sinful. Right? So market price is 20. It may be sold between $18 and $23, but 20 is not the best price. But it's not ghabn fahish. So I was sinful, but you can't do anything about it in court. Right? And you can't demand me to be virtuous. You could wave your finger at me and say, ittaqillah, and I'll say, shukran. Right? But that's not enforceable. Right? I have a friend who's a God-fearing trader. When the other party would start telling this is good, I said, don't tell me if it's a good price or bad. خليني أقرر. Let me decide for myself. He kept doing that. I asked why. He said, I don't want the other party to commit sin. And I don't want to be indirect party to the sin. So that's why there's ethics of transaction. Once we finish the section on partnerships, we'll look at some of these ethics, bi'idhnillahi ta'ala. Of course, we have to decide what we're doing after the section on transactions, but that's a separate conversation. Alhamdulillah.